Good afternoon to everybody. Welcome to the today class. There is a law of property that I am dealing about the fifth unit, where in the last class that I completed the easement. Yes, tell me that what I posted on the screen so that I could know that you are with me. I am with you. Read what I posted on the screen. Yes.
ఆ,
Yeah, I am getting your household total dialects. Manchamu, fanu, and everything.
Good afternoon, sir.
Good afternoon.
No matter what time of day it is, no matter what I am doing, no matter what is right and what is not, still remember you like this time. Good afternoon.
Yeah, this is one of the quotation of the good afternoon is concerned. Now you mute it because I could see your household dialects also in this talk. Yes. Yes, let us come to the point of our study is concerned. If you happen to see the syllabus, after the easement, that it is said that the acquisition of property through the testamentary succession. It is nothing but the testamentary succession or the transfer of testamentary succession or testamentary succession, the property will be transferred, the property will be acquired. That is the today's topic, and I will jump on the topic. This is the acquisition of the property through the testamentary succession. Now let me first tell me what is testamentary succession. Yes, any idea do you have?
Sir, inheritance, sir.
Yes. What is meant by testamentary?
Testamentary means will writing. Testator means the person who writes will.
Yes, means a person who is transferring the property in the form of the testamentary succession. Nothing but other person is acquiring the property in the form of the testamentary succession. Is it not?
Yes, sir.
Yes. Now, when it is transferred, before the death, after the death?
Before death, sir. Before death, it will be written, sir.
Uh,
Transfer will be after the death.
yes. What is the terminology can be used for the deceased in the transfer of property, especially in the will? There is a particular name for the deceased.
Dying declaration.
Prepositus.
Prepositors.
Yes, that means the person who died by living by writing the will is called the called prepositus. That is the wording that he used. Yes, now let us see.
PRE.
Prepositus. I will show you the how it can be written. This is awesome means extremely impressive. That is awesome. And now what is prepositus? I will show you here. Prepositus. Yes. Here prepositus means plural of the prepositosus, and prepositus plural of prepositosus means are prepositi. So historically a provost, the presiding officer of the various ecclesiastical bodies, that is here presiding officer, but another meaning of the prepositus means deceased. Another meaning of the prepositus is deceased, in the, especially in the wills are concerned. A head of any various clerical civil institution presiding over the official provost, and prepositus in the sense prepositus, prepositi. Yeah, that is the word they used it. Um, Prepositus. Yes. Yeah, that is the wording used it. That means a person who died. Let us see that a person who dies in succession of property in the form of will. Then what do you say this one? Your distribution of asset in case a person dies without a will. Without a will is different. Property of the person's death and a person's inherits. But there is a word they say, the deceased person means death should be there. Is it clear? Whose
Yes,
death
sir.
should be there? Testator. Who is testator?
Testator. The
A
person
person
who
who
writes
makes the will is called a testator. And another name for the testator?
prepositors, sir.
Legator.
Like that. Okay, sir.
Yes. So let us see that it is hard to cope up with when a loved one passes away. Even harder when the deceased is the head of the family. So here the head of the family is prepositus. When he prepositus no more over there, the head of the family and he is the breadwinner, and but he is having a lot of property left over there, both immobile and immovable. Some plans for succession and creative will while they are alive. So people should not quarrel each other. A good relations will be spoiled between the brothers and sisters, including the mother, means widow. That's why when he is alive, he writes the will. However, many don't foresee that the need and leave it to a chance. But sometimes people will not make it out. Okay, ipade sastana. No, we should not say that what will happen the next. So better you write a will. So in such a situation, it is tough for the rest of the family members to decide how the property will be divided amongst the and transferred to heirs, and who gets what, when, and how remain some uncomfortable questions are there. Then who is going to take what, and what is the property would be laid, how much the share would be there. Now the equal share to the women also, daughters also. Is it clear? Either married or unmarried, doesn't make any difference. Yes. So now the testamentary succession is the possible answer. See, if you write a will, then it is a possible answer that there will not be quarrel between the or among the family members. This post shares insight on what does it mean. Frequently used terms related to the testamentary succession under the Indian Succession Act 1925, characteristics of a valid will. So the will which is left over by the prepositors, it should be a valid will. Means all the conditions for the will should be fulfilled over there. The importance of the having a will, and how Hindu law governs the testamentary succession, and how the Muslim law will govern the testamentary succession, and how the Christian law will deal the testamentary succession, and how the Parsi law will deal the testamentary succession. But all the Hindus, including the Jews and Parsis, then only Indian Succession Act is there, which will give the clear idea. But when it comes to the Muslim, there the which law would be prevail over there. There's the Quran and Hadith that will be left over there, and how it should be passed. But generally, the will, they said, how much the will? Is it one third? Is it not? Is it one third only that will be given? Is it waqf or is it will where the one third would be given by the testator? Yes. In waqf property, they said usufruct only will be enjoyed. The ownership will not be given over there. But in the will, you cannot give the entire property in the will. But the gift, you can give the entire property to the gift. But it is only theoretically possible, practically it is none, nil. So in the will, they say the one third, if the Muslim law is concerned, then they will be share it to whom they want to give it, he can give it. Because sometimes the person who has taken care of him at the time of the deathbed, he may be no more the relative to it, but still he will give in the form of a will to that person to whom he likes. So now let us come to the meaning of the testamentary succession. In simple terms, it is defined as the succession of the property by will or testament. Either you can say will or you can say testament. It's a document. It is the instrument. It is in writing. And as per the applicable rule of law, as per the Hindu law, any male or female can make a will to transfer his or her property or assets to anyone. The will is treated as a valid and enforceable law, provided the will object should be what is a purposive and would not be objectionable, and it should be not against the public policy, it is not against the morals, because he cannot give the entire property in the form of a will to your neighbor when you are having their children as well as your valid wife. Is it? Yes.
Yes, sir.
Yes, very good. An important point to note here is that the transfer of property happens as per the provision mentioned in the will and not as per the inheritance law. So here the inheritance will not come over there, but what they will say, no, whatever the conditions put in the will, okay, one third should go to the my first son, another half of the movable property go to the second son, the rest is go to my daughter. Either married or unmarried, doesn't make any difference. Especially now after the amendment to the section 6 of the Hindu Succession Act. Yes, come to the, however, if the will is invalid, suppose the will is invalid or illegal, then the transfer or a devolution, generally will say devolution, or we can say bequest also. Devolution of the property happens as per the law of inheritance. Suppose the will is invalid, then what law will be coming to the rescue? Law of inheritance will come to the rescue. In the case of the Hindus, which law will be applicable?
Succession Act, sir.
Hindu Succession Act.
Yes, sir.
And for the Christians, Parsis, Jews, which law will be applicable? Indian Succession
It
Act.
is a yes, sir. Sir.
Yeah, that you have to take. For the Muslims,
Muslim Succession Act.
Muslim personal law, Shariat law, isn't it?
Yes,
There
sir.
is no Muslim Succession Act. So now what I want to say here is alternatively testamentary succession is also referred to as a right of inheritance. It is also said to be the right of inheritance only, but a testamentary because testament means in the form of a will. The will conditions are there. Then the first and foremost, when the will would be there and what should be deducted from the prepositor's estate, number one, funeral expenses, number two, medical attendance expenses, number three, artisans or casual labor, those who attach to it. Number four, legatees. Are you following me?
Yes, sir.
Who are the legatees?
Inherited person, sir. Just like legal heirs.
In the form of a will. In the form of a will, they will legator, person who execute, testator, legatee, beneficiary. Of course, the legator, as almost all, they are the legal heirs. But sometimes no, it can be also given to the neighbor, a stranger, either man or woman, irrespective of the caste and creed. The person who receives the will should have the competency, not necessarily, because in the will it will be given intravirus amere, means a child in the womb, is it?
Yes, sir.
No, yes, there is a. Let us see that what will happen in the uh, coming lectures. Yeah. Testamentary succession is also referred as the right of the inheritance. Then common terms are related to the testamentary section under Hindu law. Hindu law common terms it is important to understand the frequently used terms that might sound complicated but are easy to interpret. They are will. What is the will? A legal declaration created by a person expressing clear intention or wish with regard to how his or her property and assets will be transferred after the death. Can you say transferred after the death or distributed after the death? Which is the appropriate word?
Sir,
In
distributed means
partition, we say
distributed.
distributed.
Yes, sir.
But in the will, we will say transferred.
Distribution means our interference will be there, sir. Whereas in transfer, there will be a rule, sir.
Will take
Trans,
place.
yes, sir. Will means that is a legal document only.
Yes. Through that, the property will be transferred. So that is specifically what they used over there. The property will be transferred after the death. That is the will. Then who is the testator?
The person who writes the will is called testator, sir.
The person who creates his. Why writes? He may not write, but somebody will write. Creates. A person who creates his or her will is the testator. An executor, a person appointed by the testator for executing the will. If there is no executor to be there, then the court will appoint the administrator. Who is the administrator? A person appointed by the court for executing the will. Then who is the attestation of will? Yes, it is the process of signing the will by two witnesses verify the signature of the executant. Whether the signature is a genuine or not, or he signed it or not, with coercion, without coercion. Can the will attested may be female? Yes.
Yes, sir. Yes, sir.
Answer is you say yes. Yeah, that is the
Yes,
way.
sir.
Can the testator, then the attestator will be minor?
No, sir.
No, a capacity to contract a person only having such a capacity to be a witness. Next, F, codicil. What is codicil? A legal document made by the testator and signed by the two witnesses for making the minor changes in the will that has already been executed. Means it is a supplement to the will is called a codicil. Then probate, it is a documentary evidence of the appointment of the executor and establishes the validity of the will. So the probate means we have to say that yes, that will is a valid will and there is no other will except this one. If other will would be there, then the first will be eclipsed by the second. Is it?
Yes, sir.
The last will be prevail over the earlier one.
Yes, sir.
Good. Yes. Last point is H is a letter of administration. Then who will give the letter of administration? A certificate granted by the court for appointing an administrator of the will. So for the letter of administration, the administrator will get it and he will be appointed by the court and he will administer the execution of the will. Means whatever the shares would be there in the will, that he will see that that will be given to the legatee, that is the beneficiaries. Okay. Important characteristics of a valid will. What is the valid will? Important characteristics should be there. A testator must consider the following essential characteristics while creating his her or will. What is that characteristic A? Can you read it A? Which I am highlighting here. Yes.
It is a written document expressing the testator's clear
No.
intention,
Hmm.
clear intentions, or desire will
With
wills respect to desire with respect to transfer of his or her assets or property.
now you mute it. Yeah, it is a written document. What is that? It is expressing what testator's clear intention. What is the intention? How much that he wants to transfer to the elder son, younger son, wife. Suppose if he is a Muslim, there is more than two wives. Then how the distribution would be there, and in the will he will make it out. But when you are writing the will, don't write the everything to the wife and only 1/4 to the children, because it will be injustice on the part of it, because children are still minors, they need the more money for the growing up, and that is the reason when you are writing the will, see that the justification should be there. So that is the even though it is a self-acquired property, only he can give in the form of a will. Suppose if the ancestral property, he cannot do so, because ancestral property comes through the inheritance, is it? Yes, it can be
Yes,
created
sir.
by any person of the age 18 years or above who is capable of entering into an agreement. A will be created by a person more than 18 of age can create the will. But when he creates the will, when he is the owner of the property, number one, and when the abandoned property would be there, some of the portion will be given in the will, so that thing he can do so. The person who influenced by alcohol or fear or affected by illness or fraud cannot make a will. So a person who is executing a will, he should be a sound mind. He should not be in the intoxicated mode, nor at the gunpoint. He should have to make the will. So these are all the illnesses, fraud, if such a will is invalid will. Then the fourth one is the Indian Succession Act 1925 does not prescribe any specific format of the writing a will. There is no hard and fast rule in writing the will. The way that you want to write, you can write it, but provided that the language should be known to the I mean to say the witnesses as well as the legatees, those who are the beneficiaries. So when you write the language of the will should be known to everybody, including the witnesses. Yeah, that is the point. Then the D, that is the fourth one is the Indian Succession Act 1925 does not specify, there is no format to the writing the will, he can write any way that he wants. Number E, that is the fifth one, is minor unintentional error is a will. Uh, Suppose the minor's unintentional error in a will, let me say, error in the name, spelling, or details of the property does not alter the true intention of the testator. Suppose if you want to write Hussein, what is the spelling of the Hussein?
Hussain.
That is the Indian spelling. You know how African spelling of writing Hussein?
No, sir, don't know.
Hussein. They don't write a capital, that is small first letter of the A. They write the fifth letter of the E. A, B, C, D, E. They write Hussein. That is the African spelling. Sir, The spelling also different. Yes, American spelling color is different. British spelling color is different. What is the American spelling color?
COLOR, sir.
What is the British?
COLOUR.
Very good. Appreciate it. Yeah. So, does not prescribe specific format and the minor unintentional error is in a will. Then error in a name of the spelling details and it will not affect any intention of the testator. The testator should sign the will, which should be countersigned by the two witnesses. In cases where the testator cannot sign, thumb impression of the testator should be taken. What do you say, thumb impression? Is it right or left?
If possible, right, sir. Not means left.
Then ladies, a separate thumb
Ladies,
impression, gents, a separate thumb impression. Means either right or left. But if the gents is right, then lady is left. If the lady is right, then the gents is left, subject to the correction. Okay, now suppose if he doesn't know what I say signature, then he can put the thumb impression. Definitely he can do. And the finger thumb. But once I told you, know what is the bottom nail? That is the big toe in the of the foot toes.
halak, sir.
HULLUX or
UX. UX.
HALLUX halax. HALLUX halax means bottom and a kalvelu, not a cheti. Yeah, the G, the signature of the testator should appear at the bottom of the page or at the end of the contents of the will. So why should be the content below? Why not should the margin?
Sir, for easy understanding, sir.
He that if he make the beneath, that means he understood above and he put the thumb impression below. Means after reading he put it at the end of the text.
Yes, sir.
That is the giving the sense. Once I told you, when you want to shed buttons of the boys either down to up or up to down. If the girls whether down to up or up to down.
First, we have to put first button and last button, sir. Later, we can put the remaining buttons, sir.
Okay, that is the one way of the doing the things, so that it will be correctly maintained, whether properly tied or not. Number one. Number two, if the ladies should
Up
be
to
there from the up to down, if the gents is there from the down to up, later you can think why I said so. Okay, come to the point H. The witnesses to the will should not be the beneficiary themselves. So the witnesses who put the at the bottom of the letter, they should not be the beneficiaries. That means they should not be the legatees. That means no heirs could have to sign it. Only the neighbors or unknown persons or strangers or somebody else. They have to sign it on the will. Okay. Then I, that is called a will comes into the force only after the death of the testator. Suppose to make the will executed, to see that the will be executed, can you kill the testator?
no, sir.
If you kill, what will happen?
There will be a legal enforcement.
Disinherited. Disinherited means he
There
lose
will be
the.
there will be a case against him also. No,
There is
sir.
a case. Number one. Number two, he will be no more a legatee. Disinherited. From he is removed from the inheritance. And finally, it is not the mandate to make a will document on a stamp paper. Not that much, but it's more better to keep in the stamp paper so it's signed the legal effect. Suppose it is written in the white paper and signed by a distant relative. At the time also valid, provided you have to make validation by stamp by what I say either Franklin mission or the value should be added to the paper. Either the additional stamps or Franklin machine. Is it clear?
Yes, sir.
And a testator can also write in a paper, plain paper. Yes, he can write in a paper. It's more better the will should be registered. That is the well and good. to avoid the legal complications. Are you following me?
Yes, sir.
Yeah. Now, why is having a will important? Why the will important? Tell me. What is the importance of the will? Why do you want to make the will?
There will be no conflicts among the legal heirs, sir. To avoid legal conflicts among the legal heirs.
After the death of
That
him?
is, yes, sir. That is
Yeah.
the final word given by the testator, sir.
Yes, yes, yes. So each person wishes that his legal heirs stay apart from the cohesive family even after his or her death, that there are no fights over the property matters. After all, fair division of the property is a sensitive matter. In today's times, if it is done properly, it can make a long lasting relationship, and if done otherwise, it breaks the relations forever. సో దట్స్ వై దే సే బతుకున్నప్పుడే పంచిస్తే అయిపోతుంది, ఎవరికి ఎవరు కొట్లాట ఉండదు. లేకుంటే నేను అన్నను బాగా మంచిగా చూసుకున్నా, నేను మా నాయన మంచిగా చూసుకున్నా, మా అమ్మను మంచిగా చూసుకున్నా, నాకు ఎక్కువ పైసలు ఇవ్వాలా? ఇజ్ ఇట్ నాట్?
Yes, sir.
సో దట్ కాంప్లికేషన్స్ విల్ కమ్ ఓవర్ దేర్. So it is for this purpose making a fair will that comes very handy. The testator must clearly document his or her desires with respect to the assets that his legal heirs would carry out after his or her death. So the will must clearly state how the testator's property will be transferred, to whom it will be transferred, how much share of the property will be transferred to different heads, and so on. That should be clearly mentioned over there. But no injustice among the children. Generally, a very common question arises here as to what happens if a person dies without leaving a will behind. In such cases, the division and transfer of the property happens by way of law, that is called intestate succession. So, testate succession means by writing the will, how the property will be transferred. Intestate succession without writing the will, and how it will be transferred of the death of the breadwinner, means testator or legator. Yes. Which law governs the testamentary succession? Which law governs? In India, testamentary succession is governed by the Indian Succession Act 1925, including the interstate succession. Both the Indian Succession Act of 1925 will deal both testate and interstate succession. Most importantly, this law extends to the whole of India, but is only applicable to the wills and codices of the Hindus, Sikhs, Buddhists, and Jains by religion, but not Muslims. Sir, Muslim personal law is there. What is the Muslim personal law? Shariat law. Which year? 1936. Is it 1936 or 1956?
36, sir.
36 is the right word. Yes, sir. So according to that provision should be there where you should be followed. Suppose if it is a silent, then what method should be followed? What the Quran and Hadith says. If the interstate would be there, there is a specific ratios are there. For the women, there is a widow, this much share. If they have the children, 1 by 4 and 1 by 8. If they don't have the children, 1 by 4 under Muslim law. I am speaking. But in the Hindu law, they say equal shares to the children as well as to the
Widows, sir.
widows or the propositor wives or testator wife. Suppose the wives are two,
There will be share to the both of them, sir.
whatever the amount will come, that will be shared by the two. Does it possible in the Hindu law?
No, sir, it will not be possible.
ఎస్. సార్ ఆయనకు రెండు పెళ్ళాలు ఉన్నాయి కాదు సార్ అంటే మరి ఎట్లా? అరే నువ్వు మూడు పెట్టుకో, నీకు వద్దని కెపాసిటీ ఉంటాయి, బయాలజికల్ ఆర్ మానిటరీ అండ్ ఆల్ ద వే. పేరుకు మాత్రం పెట్టుకోకు, బికాస్ అదర్ విల్ ఎంజాయ్ ఇట్. సో నౌ ద క్వశ్చన్ కమ్స్ ఓవర్ దేర్, ఎస్పెషల్ నేబర్స్. సో కంక్లూజన్ లో ఏం చెప్పాలంటే, ఇట్ ఈస్ ఆల్వేస్ అడ్వైజబుల్ టు రైట్ యూ విల్, నాట్ వెల్, ఇది విల్. It is always advisable to write a will. Naturally, when you write the will, you should be in the either a big uppercase. You can write it, or you can keep it in an inverted comma or a single or double. So write a will. Thought and fair will should be there. Write a will will thought and you fear will. Uh, so, will in case of any ambiguity or in the absence of a will, there is a possibility that the legal heirs of the deceased would engage in unwanted, ugly legal battles. See the word they used. What the word they used? Unwanted, ugly legal battle for claiming the rightful share. సార్ సంపాదించిందే మొత్తం తింటలేం మనం, ఇక మా తాత ముత్తాతలు నాయన ఇచ్చింది తింటామా అండి? సార్ సంపాదించే వరకు అయితే తినాలి కదా సార్ అంటారు. వాట్ యు సే?
Yes, sir.
సో దిస్ ఈస్ ద జనరల్లీ హౌ a testator will get the transfer or acquiring the property in the form of a will. So this is the one of the question paper where we have seen it and we did it. So let us see. Not question paper. This is the syllabus. In the syllabus it is given over there. Then we saw it. So what is the another point for the as per the syllabus is concerned? Yes, now I am turning back to the syllabus. Then the comes the acquisition of the property through the testamentary succession. So that is nothing but a will. ఇప్పుడు విల్ కి కోడిసిల్ కి డిఫరెన్స్ చెప్పండి సార్.
Sir, will is a written by the testator, sir.
ఓకే,
Whereas codicil is the, I don't know, sir, about the codicil.
ఇందాకనే చెప్పాను కదండి, సప్లిమెంట్ టు ద విల్.
Okay, sir.
అది
That
అది ఒక పిల్ల అన్నట్టు, తోక. అది
that means
ఈ తోక ఎవరికి ఉంటదండి?
illiterate person, sir, having no literacy.
అట్లా లేదు. ఇప్పుడు ఏంటంటే సపోజ్ ఏదైనా మిస్ అయింది అనుకోండి వీళ్ళ, అందులో ప్రపోర్షనేట్ ఇవ్వడంలో కొంచెం పర్సంటేజ్ కొంచెం పెంచుతాను. ఎందుకంటే పెద్ద కొడుకేమో ఐఏఎస్ ఆఫీసర్ ఉన్నాడు, చిన్న కొడుకేమో క్లర్క్ ఉన్నాడు. అటువంటిప్పుడు ఏం చేసింది వీడు, అరే రే వాడు ఐఏఎస్ ఆఫీసర్ కదా, ఎట్లయినా వాడు వీడికి తక్కువ ఉన్నది కానీ వానికి ఏం చేస్తుంటే, అరే నువ్వు 20% తీసుకోరా, తమ్ముడికి 80% ఇరా అని అది రాస్తాడు. సపోజ్ ముందు గారికి 50-50 రాస్తాడు. తర్వాత అనిపిస్తుంది దిస్ ఫెలో ఈజ్ హ్యావింగ్ ఎ గుడ్ ఎర్నింగ్ కెపాసిటీ and that fellow doesn't have the earning capacity, even though I tried to make them to give the same education, because the elder బుద్ధిగా పని చేసుకున్నాడు, చిన్నోడు గార్వాళ్ళతోని ఖరాబ్ అయిండు. గార్వాళ్ళని ఏమన్నారండి ఇంగ్లీష్లో?
Making don't know, sir.
బై ద ఫాండ్లింగ్, FONDL అయింది, గర్వం చేయడం అంటారు. బై గివింగ్ ద లీనియన్సీ.
Yes, sir.
ఫాండ్లింగ్ అంటే చిన్నపిల్లకు ఫాండ్లింగ్ అంటారు. సో
love also.
Yes, the more love would be there, that turn into the that is a bad effect to the children. ఇప్పుడు ఏదైనా తప్పు చేసింది అనుకోండి, ఒకసారి గొప్పడాలా, రెండోసారి కొట్టాలా కూడా. ఎందుకంటే సో దట్ హీ కుడ్ నాట్ డూ ఇట్ అగైన్. The reason is if we don't do a moderate punishment, that fellow will repeat it. So if you give the moderate punishment, at least by punishment he will fear it. Is it?
Yes, sir.
So if you want to change the will, if you want to amend the will, if you want to add something to the will, that is called codicil. Means supplement to the will is called codicil. కాదు, రిప్లేస్మెంట్ ఆఫ్ ది విల్ కాదు అది.
Sir, edited, sir. Edited already.
అది అడెండా అనుకోరాదండి.
ఎడిటింగ్ ఆల్సో.
ఎడిటింగ్ ఏంటంటే మెయిన్ దానికి ఎడిటింగ్ చేసి కోడిసిల్ పెడతారు. ఇప్పుడు అమెండ్మెంట్ తిరిగి అనుకోరండి, ఇప్పుడు అమెండ్మెంట్ వచ్చింది, మెయిన్ దానికి అమెండ్మెంట్ అన్నమాట. ఆటోమేటికల్ ఇది దాంట్లో రిఫ్లెక్ట్ అవుతుంది. ఎందుకంటే డివిజన్ చేసేటప్పుడు ఏమవుతుంది, ట్రాన్స్ఫర్ చేసేటప్పుడు ఏమవుతుంది, దిస్ విల్ బి కన్సిడర్డ్, codicil will be considered. So will ki codicil ki difference ఏంటి? A supplement to the will is codicil, but not the replacement of the will is codicil అని చెప్తారు. Is it?
Slight changes.
Yes, right. Suppose if I make that here, what is exactly codicil for you and definition ఏమి పెడతారు? CODICILE. Codicil means, చూడండి, how do you pronounce codicil. ఇట్లా ప్రొనౌన్సియేషన్ ఏంటిది? codicil. codicil. So ఇదేంటంటే an addition or supplement that explains, comma, modifies or revokes a will or part of one, దాన్ని codicil అంటారు. So what is a codicil in your law? If you see it, it is a legal instrument made to modify an earlier one will. మాడిఫై అన్నాడు, రిప్లేస్ అనలే ఇక్కడ. రిప్లేస్ కి మాడిఫై కి డిఫరెన్స్ ఉన్నది. రిప్లేస్ అంటే ఏంటిది? మొత్తం సబ్స్టిట్యూట్. కానీ మాడిఫై అంటే కొన్ని ప్రొవిజన్స్ కొన్ని మాడిఫై చేస్తారు. అది ఫాలోయింగ్.
Yes, sir.
సో దట్ ఈస్ ద మాడిఫైయింగ్ అంటారు అన్నట్టు. అంటే అపెండిక్స్ అనుకోరాదండి, ఒక సప్లిమెంట్ అనుకోరండి. సో ఏ లీగల్లీ బైండింగ్, కోడిసిల్ కూడా లీగల్లీ బైండింగ్ అయితే చూడండి ఇక్కడ చూడండి. ఏ కోడిసిల్ ఈజ్ ఏ సప్లిమెంట్ టు అన్ ఎగ్జిస్టింగ్ విల్ దట్ మేక్స్ సమ్ ఆల్టరేషన్స్ బట్ లీవ్స్ ద రెస్ట్ ఆఫ్ ది విల్ ఇంటాక్ట్. అంటే అర్థం ఆల్టరేషనే చేశారు. కాకపోతే ఏంది, ఇప్పుడు నారో పాయింట్ ని బెల్ బ్యాటన్ చేయొచ్చా అండి? బెల్ బ్యాటన్ ని నారో పాయింట్ చేయొచ్చా?
సార్ నేరో ప్యాంట్ బెల్ బాటమ్ చేయలేము సార్, కానీ బెల్ బాటమ్ ని నేరో ప్యాంట్ చేయొచ్చు సార్.
దీన్ని ఆల్టరేషన్ అంటారా లేకుంటే రిప్లేస్మెంట్ అంటారా?
ఆల్టరేషన్ సార్, నాట్ రీప్లేస్మెంట్.
రిప్లేస్ అనరు, దాన్ని ఆల్టరేషన్ అంటారు. అందుకోసమే
సార్
సమ్ ఆల్టరేషన్స్ బట్ లీవ్స్ ద రెస్ట్ ఆఫ్ ది విల్ ఇంటాక్ట్. అంటే పైన మాత్రం అదే ఉంటది, కింద మాత్రం ఆల్టరేషన్ అవుతుంది.
ఎస్ సార్.
ఎస్, ఇట్ ఈస్ ఎ లీగల్ డాక్యుమెంట్ దట్ ఈజ్ ఎ లీగల్లీ బైండింగ్ యాజ్ అ ఒరిజినల్ విల్. అంటే కోడిసిల్ కూడా లీగల్ డాక్యుమెంట్ లైక్ ఏ ఒరిజినల్ విల్. కాకపోతే కోడిసిల్ actions will be reflected in the main will, original will. So a codicil must be on a separate sheet or of paper of the will and to be signed and dated and witnessed in the same way as a original will. సేమ్ ఎట్లయితే ఒరిజినల్ విల్ రాస్తారో ఆ విధంగా కోడిసిల్ కూడా రాస్తాడు. మాడిఫైయింగ్, రిప్లేసింగ్, రెస్టిట్యూషన్ ఆర్ చేంజింగ్, రిపీలింగ్ కొన్ని ప్రొవిజన్స్, but not the entire will. But it will be again signed by the testator plus attested by the
విట్నెసెస్.
how many?
నో సార్.
Two witnesses.
లీగల్ టూ విట్నెస్.
These two witnesses ladies or gents?
ఎనీ సార్.
అది హిందూ లాల, ముస్లిం లాల.
నో సార్, పాస్ ఆన్, డోంట్ నో సార్.
ఇప్పుడు ముస్లిం లాలో ఏమంటదంటే, ఇప్పుడు మ్యారేజ్ కానీ ఇంకేదానికి కానీ విట్నెసెస్ అనగానే ఏమవుతుందంటే 2 female is equal 1 witness and 1 male is equal 1. అయితే 2 witnesses ఉంటదానికి సార్ నేను 4 female ని పెడితే సార్ invalid, because at least 1 male should be there. కాబట్టి 1 male 2 female ఉండొచ్చు, కానీ 4 female ఉండద్దు. is invalid. At least that is the reason they say 1 male and 2 female should be there. The valid 2 witnesses will be either for the marriage or for the any other thing they want to attest it. They will be taken in such a way. ఇది మనం 1:2 అంటారు. ఎందుకంటారండి 1:2 అంటే ఒక లాజిక్ ఉన్నది ఇందులో. అఫ్ కోర్స్ ఇస్ నాట్ ఏ డిబేటబుల్. 2 ఎందుకంటారంటే she already enjoyed the thing, she got married and she got another husband, sorry, not husband, so husband will take care of it. So it is a 1 share for the female and 2 shares for the
మేల్ సార్.
మేల్. ఎందుకంటే ఇది బ్రెడ్ విన్నర్ కదండి. వీడు ఫాదర్ మదర్ ని చూసుకోవాలా, పెళ్లి కాని సిస్టర్ ని చూసుకోవాలా, ప్లస్ వైఫ్ ని చూసుకోవాలా, వైఫ్ పిల్లలని చూసుకోవాలా. అది కూడా ఒక వైఫ్ ఉంటే, ఇద్దరు వైఫ్ ఉన్నాయనుకోండి మరి ఇద్దరు వైఫ్ ని చూసుకోవాలా, మరి వాళ్ళ ఇద్దరు పిల్లలను చూసుకోవాలా. ఇజ్ ఇట్ నాట్? Is it not the financial burden on him?
Yes sir.
So that is the way it is taken or in consideration. But depending upon the situation is concerned. But nowadays the women also earning more than the
men,
men.
sir. Men.
And more employment are going to be created soon for the women. And women plays an important role in each and every activity of the human life. Is it or not?
Yes, sir.
మీరు ఎప్పుడైనా అనుకున్నారా అండి బస్ కండక్టర్ లేడీస్ ఉంటారని?
Yes, sir. In early days, I don't think, sir. But
ఈవెన్
nowadays,
డ్రీమ్ లో కూడా ఆలోచించిండ్రా అని.
no, sir.
బట్ నౌ డేస్
Women conductors, not only women conductors, sir. Trains also.
I saw in the
Taking.
train also one train I saw it, but not usually, but one train that to be not goods train, that is a passenger train only. That is because the goods will run in the night, but these people will write. Of course, the two drivers are there. The two also women, but not one man and one woman, unless they are a wife and husband. Are you following me? Yes, let us come to the point. So, thank you very much for being awesome. And here, awesome means what is awesome? Awesome. Actually,
Beautiful.
awesome కాదు,
Beautiful.
awesome.
Beautiful, sir.
Brilliant అన్నట్టు. Awesome అది, awesome కాదు, awesome. So, thank you
Yes,
for
sir.
being awesome. So, that is the brilliant for taking part in my online class. And in the next class we will see the what is the next item which I am going to show you now. The next item, according to the syllabus is concerned, yes, will codicil we made the explanation here, and a capacity to execute a will again we will try upon, and the nature of bequest we will try upon tomorrow. Then executor of will, and entirely will only there. Tomorrow again I will deal the other features of the will, then the kinds of the will. Then I will go to the later part, the rights and obligation of the legatees and legator. So with that, the unit 5 will be over. So with this, I would like to take the leave. Thank you very much. Once again, I will show you the my thanks thing, and I'll see you tomorrow. If there is no class tomorrow, then I will inform you in advance. If no information would be there in advance, presumption is
Attend the class.
yes. So thank you very much for your patient listening, and I'll see you again tomorrow. And have a good day and bye.